A very warm welcome to lesson number 27 in our 50-part series on the law of evidence. In today's lesson, we will be having a look at sections 25 and 26 of the Indian Evidence Act, which deal with confessions and the police. In our previous lesson, we had a look at section 24, which lays down the principle that if a confession is caused by any inducement, threat, or promise, then any such confession is irrelevant. That basically means that a confession should be given with the free consent of the person making the confession, right? Also, let me remind you, what is the confession? A confession is basically an admission of guilt. So when a person concedes that he has committed an offense, that is a confession. Also remember that confession applies only to criminal cases, right? Whereas admissions apply to both civil and criminal. Okay, so now we will be having a look at section 25. Let's see section 25. No confession made to a police officer shall be proved as against a person accused of any offense. Now, what is the meaning of shall be proved? Right? No confession shall be proved, which means the confession shall not be proved. What that means is evidence cannot be given for it. When you say shall not be proved, what that basically means is that evidence shall not be given, shall not be allowed to be given, right? Because that basically means that it is irrelevant and evidence cannot be given for that fact. Okay, so what we learn from here is that no confession made to a police officer is relevant. Now, why do you think that has happened? Well, the answer can be kind of inferred from what we saw in section 24 itself, right? There is a belief that when you go to the police and the police extracts a confession from a person, right, it is possible that they might have used some brute force, they might have threatened him, and it might never be possible to know whether the police did so or not. And therefore, as a matter of precaution, it has been incorporated under section 25 that a confession to a police officer is of absolutely no evidentiary value. So you can see this point being made by the Supreme Court as well. It says that a police officer is inherently suspect of employing coercion to obtain a confession. Therefore, the confession made to a police officer under section 25 should be totally excluded from evidence. So, since it is believed that a police officer inherently is likely to use coercion, the consent cannot be free. The legislative policy and practical reality emphasize that a statement obtained while the accused is in police custody is unlikely to be a product of his free choice. And as we saw, it is important for a confession to be the result of one's free choice and his own free consent. Now we'll have a look at section 26. Make sure you pause the video and read this section a little carefully. Section 26 also is based on the same principle as section 25. The principle being that it is expected that the police officer would exercise coercion in order to obtain a confession. Just pause the video and read this section a little carefully. Now you can have a look at section 25 and 26. I have placed them both adjacent to one another so that you can compare them and see them more carefully. It's important for you to remember that seldom is a provision in a statute repeated, which means that when there is a new section, it is definitely adding some new data that goes beyond what has been given in the previous section or in any other section. So just see as to what the difference is, and then we will go further into the lesson. Let us have a look at section 26. No confession made by any person while he is in the custody of a police officer, unless it be made in the immediate presence of the magistrate, shall be proved as against such person. Now, to make sense of a statute, as I've always told you, try to ignore the beginning, whatever you find as a qualifier between the two commas. Okay, so let's just ignore this for the time being, and then you can get an idea of what the main point is. So the main point here is that no confession made by any person while he is in the custody of a police officer shall be proved as against such person. So now when you contrast section 25 and section 26, section 25 says that no confession made by an accused to a police officer shall be proved against such person. 26 talks about custody. Okay. Now, what is custody? Custody means that you are within the control of the police officer. It doesn't necessarily mean that you are within the lockup for that to be custody. It does not mean that you are within the lockup alone. You are in the police custody if you find yourself physically within the sphere of control of the police officer. That's when you are in his custody. Okay. So no confession made by any person while he's in the custody of a police officer unless it is made in the immediate presence of a magistrate. Okay. Before I explain this point to you, I want you to notice something. Here, when you see section 26, it talks about a confession in the body made by any person. Okay. Whereas the title, this title here, talks of the confession by an accused. I hope you see the difference. The title of section 26 talks about a confession by an accused, whereas here it talks about a confession made by any person. So which of these two is correct and which one is wrong? Just give it a thought. You see, when you see this here, it becomes quite clear that given the context of section 26, which is determined by section 25, which is determined by section 27, also section 24, it becomes quite clear that here we are dealing with the confession of the accused, right? So here this any person can be construed as accused because of the context. So first let us look at what section 25 tells us. Section 25 tells us that, let us say this is the person who is accused of an offense, okay? And now when he makes a confession to the police officer, when he makes a confession to the police officer, then this confession that he makes to the police officer is not relevant. That is what section 25 tells you. Now, in this case, he is speaking to the police officer because that's what section 25 says. What section 26 says is that when the person is in the custody of the police officer, then no confession made is relevant. So think of it like this. Let us say this is your person A who is accused of an offense, okay, and now he is in the custody of the police officer. The police officer is maybe here, okay. So what we understand is that a confession is not relevant even if a person is in the custody of the police officer, because what you believe is that if there's a fear of the police officer here while speaking to him, then there is also the fear when the police officer has your custody. So when you're in the custody of the police officer, there is an equal fear. However, there is one exception. So what is the exception? Let us say a person is in the custody of the police officer, right? So he's already within the custody of the police officer, but there is also the immediate presence of a magistrate. So think of it like this. Let us say this is a person who is in the custody of a police officer. Okay, so here he is in the custody of a police officer, and here's the police officer because of whom he's scared. That's what the statute tells us. So he's on his table here, sitting on his table. Okay, here's your police officer, but right here is also a magistrate. Okay, so when there's a magistrate also sitting here on his table with his hands here, his legs here, okay, so when there's a magistrate also here, then there is no fear of the police officer because you have the magistrate here. That is what the principle is, if you have to think about it, that the accused does not have to fear the police officer when there is the immediate presence of a magistrate, and therefore under section 26 you have an exception. Ordinarily, a confession that is made in the custody of the police officer is not relevant. However, if it is made in the immediate presence of a magistrate, then it is relevant. Now, what is the meaning of this word immediate? Right? Immediate means im mediate, which means there's nothing in between. There's nothing that mediates. It means that you are in the direct contact. Having had this brief discussion on section 25 and 26, I want you to focus on a point. That point is that there are two questions. The first is to whom the confession has been made, and the second as to where it has been made. If you pay a little attention, then you realize that section 25 deals with the question of to whom it has been made. So it says confessions which are made to a police officer, right? Whereas in section 26, it talks about the place where it is made. Where is it made? In the custody. So I hope you realize this. Section 25 and section 26 deal with two very distinct matters. The first is about to whom it is made, right? So section 25 tells you that it is made to a police officer, okay? And section 26 deals with where it is made. It is made in the custody of the police officer. Let me give you an example to illustrate why this is so important. Let us say we look at here section 25. This is your section 25, okay? So this is your accused, okay? And this is the police officer. Let us say he makes a confession to the police officer. Now, it does not matter where he makes it. Maybe he might make it in the police station. Maybe he might make it in the theater. Maybe he might make it in a playground. That doesn't matter, because section 25 does not deal with the place where it is made. It only deals with the person it is made to. Okay, that's the first point. Let me give you the example for section 26 now. Okay, so now section 26, like I said, deals with where it is made, but it does not deal with whom it is made to. Let's see how this plays out. Let us say you have A who is in prison, okay, not in prison, he is in just police custody, okay, let's say he is in police remand. Now, the police officer is here, okay. Now, when you talk of section 26, let us say there is one person who is serving tea in the police station. So there's a chai wala. The chai wala has his cups of tea with him, okay. Now, here A, the accused, is in the custody of the police. Let us say he confesses to this chai wala. Let us say he confesses to this tea vendor that he has actually committed an offense. Now, whom has the confession been made to? It has been made to the tea vendor. Does section 26 concern itself with to whom it has been made? No. It only concerns itself with where it has been made. Has it been made in the custody of the police officer? The answer is yes. Therefore, it is important for you to remember that let us say a person makes a confession in the custody of the police officer to his tea vendor, or he makes a confession to his friend, or he makes his confession to anybody else. It does not matter. If the confession has been made to any person in the custody of the police officer, section 26 will apply. The only exception is the exception that is given in section 26 itself. So think of it like this. Let us say A makes a confession to this tea vendor, to the chai wala. The police officer is here. But also, as he makes the confession to this tea vendor, this is made in the immediate presence of the magistrate. Okay, so the magistrate is sitting here again. So the magistrate is sitting here and he makes it in the immediate presence of the magistrate. Like I said, immediate means there's nothing in between. That's what immediate presence means. So when it is made in the immediate presence of the magistrate, a confession that is made to any person becomes relevant. So let's think of it like this. To whom has the confession been made? When it's made to a police officer, that is the area of section 25. That's where section 25 operates, okay? When it is made to a police officer. Next, when it is made in the custody of a police officer, then section 26 applies. And when we see section 26, we also see this word called magistrate in section 26 itself. Okay, so we saw magistrate in section 26. However, now I want to ask you a question, and I would like you to answer this question either in the comment section or you can mail the answer to me. The question is, let us say a confession is made to a police officer. So a confession is made to a police officer in the immediate presence of a magistrate. So there's a magistrate sitting here. Okay, he's sitting on his chair. Okay, and now you make a confession to a police officer. Is this also protected by section 26? Is that also an exception that is given under section 26? So remember that confession to a police officer is something that is seen under section 25, which we have understood is not relevant. So you confess something to a police officer, no matter where you are, whether you are in an amusement park, whether you're in a police station, whether you're in the theater, it is not relevant, right? But what if there is a magistrate in the immediate presence? Does that make it relevant? Let me know the answer. I will not discuss the answer to this for the time being. Just make sure you remember the point while answering this question, that section 26 deals with the point of where, right? Which means section 26 does not deal with this question of to whom it is made. Likewise, when we talk of section 25, section 25 deals with the question of to whom it is made. It is made to a police officer, but section 25 does not deal with the question of where it has been made. That is not the subject matter of section 25. So with this, it is possible for you to answer the question that I asked you. In this discussion of section 25 and 26, you may have noticed that there appears to be a presumption that a magistrate is a good person and a policeman is not, right? I'm oversimplifying this for the sake of the discussion, but you must have noticed that when you see the statute, it appears to lend a lot of credibility to the magistrate, but not so much to the police officer. Think of it like this. What we just saw was that, let us say this is an accused person, okay? Now, when you have the police here, you are thinking of the police as someone who will bully him, right? But we are thinking of the magistrate as someone who will actually be fair, because now the magistrate is very fair, and therefore if the accused makes a confession, then it must be with his own free consent. So we are believing that the magistrate is to that extent good and the police is not. Well, in many cases it also is true, but let me ask you a different question. Alright, so my question is this. Let us say this is a person who is in the custody of the police. Okay, so this person is in the custody of the police. Now he is making his confession maybe to the tea vendor here. So this person here is selling tea, and here you have the policeman, right? The person whom he is scared of because he has a big stick and he has a gun. Okay, so this is the police officer. But we also have alongside here the magistrate. Okay, so he's making a confession to the tea vendor, and here you have the policeman and here you have the magistrate. So until now what we saw was, we thought that maybe this person should fear the policeman. So the policeman has to be feared, but the magistrate is somebody who is very good, and therefore there is no fear when there is a magistrate. Now my question to you is, suppose this person is in the presence of a police officer who is presumed to be not good, and it turns out that the magistrate is also not a good person. So now the magistrate compels this person to make a confession. Then what happens? Well, in such a scenario, we look at section 24, which we studied in the previous lesson. Section 24 applies to every person in authority, including a magistrate, which means that if a magistrate compels a person to confess, then that would be hit by section 24, and it would also be hit by article 20 subclause 3, which is the right against self-incrimination, right? So remember that when a magistrate does not behave properly, as regards the confession, which means he offers a threat, inducement or promise or a coercion, then in such a case it is hit by section 24, because section 24 applies to the magistrate as well. However, when we talk of section 25, then section 25 talks of a situation with the police where you do not even see whether the police officer is being nice or not. Maybe this police officer is very good, maybe he's very gentle, he's absolutely non-violent, and he's very honest, not corrupt. Now, if a confession is made to this very good person, this excellent police officer, section 25 says that even so, we do not allow a confession made to a police officer to be relevant. So section 25 is specific to police officers, whereas section 24 applies to any person who exercises coercion. To conclude, let me again take the point regarding the question that I asked you some time back. Confessions to a police officer in the presence of a magistrate, is it relevant or not? You need to see that this part here, confession to a police officer, this is taken from section 25. And then when we talk about the presence of a magistrate, this is something that is borrowed from section 26. Now, when you're asked this question, say in competitive exams like the judicial service exam or any other law related exam, if you're asked the question, what is the relevancy of a confession made to a police officer in the presence of a magistrate? Most of the times, most books and answer keys will tell you that this is okay, it is relevant because the magistrate is present here. However, I'd beg to differ, and therefore I want you to research this by your own self and let me know. You see, section 25 deals with confession to a police officer and it does not give you any exception. What that means is, if a confession has been made to a police officer, which means now you have your police officer right here. Okay, so your police officer, he has a long stick with him here. Okay, and he has a gun in the other hand. Okay, so now when a confession is made to a police officer, okay, it does not deal with the question of where it is made. Okay, it does not deal with the question of the surroundings. So let us say when we look at section 25, it does not make any mention of the surroundings, it does not make a mention of where it is made, which means that it could be anything around them, which means it's also possible that you have a magistrate here who's sitting here, right here. Okay, but section 25 does not talk about where, it only talks about the person to whom it has to be made. And therefore, if you ask me the answer to this question, according to me is that it is not relevant. I hope you get the point. The reason that it is not relevant is that it has been made to a police officer. Let us say it was made to someone else. So let us say you're in the custody of the police officer. The police officer is here, he's looking at you, but you make the confession to your other friend who is right here. Let us say you make the confession to this person. Now you are in the custody of the police officer and not making a confession to the police officer. This is the area of operation of section 26, and section 26 makes the exception of a magistrate. Section 25 does not. Therefore, my answer to this question is not relevant. I hope this lesson was of use to you. Thank you so much for your patience. Good day.